back of what's going on with COVID-19 at the moment, where we bring together groups of experts around a specific theme. Yesterday was finance, and today is all things legal. And we have some brilliant ex-legal experts from our friends at Kemp Little and also Kepler Wolf. So before I hand over to Andy Moseby, who is corporate partner at Kemp Little and also sits on our governance board, thank you, Andy. I'm just going to talk briefly about the other events we've got coming up this week. So tomorrow at 9, we have our International Management Webinar, breakfast briefing. So that was an existing event that's been reframed for the current climate. So in that you'll be able to get to grips with managing international offices at this time, how to focus on business development and growth of existing clients, and lots more. It's a really interesting panel, so please do sign up. And then on Friday, we have another BIMA Hangout, and that is specifically around mental health and wellness. And we have 3 of our members of our Inclusion and Diversity Council joining us for that one. So last but not least, on Thursday, we will be launching the next week's events. So if we are not doing something that you'd like to see us doing, please just give us a shout and we will try and make it work for next week or the week after. And is there anything you'd like to go through just on the format for this morning before we hand over to Andy?
Sure, thank you. Yes, I'll be very brief. So the way it's going to work is that Andy, our host, is going to kick things off. You should see at the bottom of your screen a Q&A button. Please use that to ask any questions that you have for the panel, and they'll try to answer as quickly as they can. And at the end of every section, they'll kind of go back to your questions. So please ask as many questions as you can. If you were in the webinar yesterday, you'll see there was a few different questions asked, so don't be afraid to ask anything. And also you can ask anonymously, so don't be afraid to ask questions. But and share the link with any of your team that you think could benefit from this meeting, because it'd be really useful for a lot of people to join and ask as many questions as they can. But so that's just really my point. I'll hand over to Andy now. So Andy, if you want to kick us off and get going.
Sure. Thanks, and thanks everybody. Hi, yeah, so we've got a number of people around the screen that you can see who can give advice on a variety of different topics. I think from the responses that we had leading up to this, there were a couple of things that were clearly on people's minds. People want to know about the contracts, and particularly kind of force majeure, but also how to get out of contracts or renegotiate contracts, or should they be looking to terminate contracts. So Tanya Williams, who's a partner at Kemp Little in our operational team, is here to help, as well as John Haggis from Kepler Wolf. People are also interested in employment law issues, particularly around their employees and employee status, but also some of the measures that the government are looking to put in place in order to protect salaries. And Justin Terry, who on my screen is sitting directly below me, this is like Celebrity Squares or something, it's great, will be able to kind of answer those questions for you too. And then also Joanna Conway, who's in our IP and disputes team, can also help in terms of what happens if people do start pulling out of contracts? What happens if people start getting into a dispute as well? I can take questions in relation to finance and talk a little bit about the kind of government grants and the government loans that we're starting to see a little bit more detail on. One thing I did want to talk about, which I can do at the end, is also the problem that a number of our clients are having about signing documents remotely, particularly signing deeds remotely. And there's a couple of important things to think about when it comes to signing deeds, particularly now that we're into the situation where the government are banning more than 2 people getting together, which means putting a witness in place for a signatory is going to be quite difficult. So first, there's a couple of questions that are already starting to come in, so please do use that Q&A function around kind of force majeure. So maybe if I pass over to John and Tanya. John, starting from you, I mean, what are you seeing in terms of the clients that you're speaking to about contracts and force majeure, and how is force majeure going to operate in the time of COVID-19?
Yeah, so we are seeing quite a lot of queries coming in about this. And to be honest with you, it's coming from the customers. We act for a lot of suppliers, and it's coming from a lot of customer side who are just throwing it out there thinking it's the golden bullet to get out of contracts. Whereas in actual fact, force majeure is not necessarily the golden bullet that people are looking for here. And it might be the wrong avenue to go down if you're trying to manage your obligations under a contract. Because what force majeure is under English and Scottish law, it is a contractual provision. So whether or not someone can rely on it, the first thing you need to do is look into your contract and see what has been drafted around force majeure. Because in essence, what force majeure is about is where an unforeseen event, a major event happens, which prevents typically one party being simply unable to perform the contract. And that doesn't mean the contract has become more expensive or more difficult to perform. It really must be unable to perform it. And then what your contract is likely to then go on and say is, well, what happens next? Does it just mean we get to suspend or delay? Does it give the other party the right to terminate? So, you know, if I'm honest, typically force majeure contracts we wouldn't be glossed over in the olden days before epidemics, but they would be not the main point that people would typically look to negotiate. So we're going to have to look at these and see what was put in place, and then see what the clients have signed up to and how that fits into the actual events.
Thanks, John. Tanya, maybe I could pass this over to you as well. I mean, what are you seeing in terms of contracts and clients coming to you for advice? How have they been drafted, and do they work, if people are looking to postpone or to be able to kind of terminate contracts?
I think that we're getting a variety of queries coming in from clients. And again, we act for both suppliers and customers. So it depends on which side of the fence I'm sitting on as to the advice I suppose I'm giving. But as John rightly pointed out, the force majeure clauses, probably in some of the bigger contracts, are paid a lot more attention in the drafting.
Yeah.
And so I think in those sorts of large scale outsourcings, or when there's high value deals, the clients that we've got anyway, I suppose they spend some time looking at those in the drafting. I think if you haven't got the protection of a force majeure clause, you can potentially look at frustration, whether the contract is frustrated. That's a common law right rather than a contractual right. But again, it's a very, very high threshold. You have to basically have a situation whereby you are prevented from performing the contract. And as John rightly pointed out, it's not just simply more expensive or a little bit more difficult, or you might be doing it but slightly late. It's that there is no way of actually performing the contract. So I think those two opportunities, depending on, again, how the contract is drafted and the situation at hand, might give suppliers potentially some wriggle room. But I think customers are going to have to be looking at all sorts of other provisions in a contract to see whether they've got protection there. And they could be things like liquidated damages for delays, service credits for service level breaches, termination triggers potentially if things are getting that bad that you might need to have an out or give you some leverage to have a conversation perhaps. We can go into more detail about those if there's any sort of specific questions that people may have as well.
Okay. Thank you. And Joe, just to bring you in here as well. So I guess what advice would you give to agencies and businesses that find that people are starting to potentially breach their contracts or say that we can't perform what we've agreed to perform? What rights would they have, and what's some practical advice that you could give them?
Yeah, so I'm coming at this from the dispute lawyer's perspective. So we're getting a lot of queries in, particularly in relation to contracts where maybe there's been problems in the past, or it's a very high value business critical contract. And in those situations, exactly what John and Tanya have talked through, those are all the relevant things you need to be thinking about. But you also then need to be putting in place certain steps to protect yourself. So if you're the contracting party who's in the position where you can no longer perform, then you may need to send a force majeure notice. It will, as Tanya and John said, depend on what your force majeure provisions say, and you need to look at those very carefully. But if they are applicable, then you will need to send the notice. And something that we see people fall down on a fair bit is they either don't send those notices or they don't send them in accordance with the notice provisions in the contract. and that can actually be fatal. It's not always, but it's just little things like that you need to be really careful on. So I'm afraid it's all in the detail. You have to go to your contracts, do a review, work out which ones are your priority, where there's a performance issue, and then follow through the contractual process, dot the I's and cross the T's. If you're on the other side and you receive a force majeure notice, then you need to scrutinize it quite carefully. Is it actually the case that performance is prevented? And again, this will come down to what does your clause say? But the courts are quite strict in terms of how they've interpreted force majeure clauses in the past. So they can't be used as an excuse. So if there are actually other reasons why the performance wasn't being performed adequately, then force majeure and COVID-19 won't now jump in to save that party and prevent them from being liable. So the advice we're giving at the moment is if you receive a force majeure notice, you should be going back to the party that sends it to you and actually checking and interrogating them as to why they say they can no longer perform and why that specifically links to the COVID-19 pandemic. So those are some sort of things you need to be thinking about. If you get into the territory of contracts being terminated, then it's a very difficult and high risk situation, because wrongful termination. So if a party says, I believe I've got the right to terminate this because you're not performing, or because there isn't really a force majeure, whatever the context, it's incredibly important that that risk assessment is taken properly, because if you wrongfully terminate, or somebody wrongfully terminates your contract against you, that in itself is something called a repudiatory breach. So it's a very high level breach which entitles the other side to terminate itself. So you actually end up in a situation where either one or both parties are saying they've terminated the contract. So it's incredibly important, if you're in that situation, just to sort of take a step back and look at who's actually in the right here, whether this is the correct approach, and also whether actually, as Tanya and John have alluded to, this is, maybe you should be having commercial discussions instead. Maybe you should be trying to agree some sort of variation to performance instead. Is there something else in the contract that would allow the parties to agree a way through this without reaching this sort of cataclysmic point where you're both saying you've terminated? And just one final point, sorry. The other thing we're seeing parties fall down on frequently is if you are agreeing a variation to your contract, a variation to performance that's expected, or you're agreeing liquidated damages aren't applicable, whatever it happens to be to keep the contract alive, do look at what your contract says in terms of formal variations. The courts have recently been extremely strict in terms of how you must contract any variation. And if you don't do it in accordance with the contract, usually it has to be in writing and signed by both parties. If you don't do that, the courts are more likely than not to say that's not a formal variation and it's not a contractual variation. So that's another tip in terms of just protecting yourself in these really difficult circumstances.
I just ask a question for Joanna, if that's okay.
Yeah, go, John.
So what would your advice be, Joanna, for clients who want to have that conversation with their suppliers or their customers? Do you think it should all be done on a without prejudice basis, so the other party can't be shrewd and say, oh, you're not going to be able to perform your contract, therefore I'm going to try and use that to get out? How would you recommend the approach here?
Yeah, so just for that's a really good question, John. Just for the audience, what dispute lawyers are sort of talk about commonly is having open correspondence with the other side. That's your sort of normal discussions, email, phone, whatever it happens to be. If it's open, it means it can be referred to in court down the line. So if the worst happens and your amicable discussions trying to agree a way through this go wrong, then those discussions could be used in court to evidence what was going on. Now, the way to protect yourself against that is, as John alluded to, you can have without prejudice conversations, and those will not be open to the court. So it's a private forum where you can be a little bit more open, you can make concessions with the other side. So bear in mind you've got those two routes and what they mean. And without prejudice is certainly a really valuable option at the moment. What we're typically advising now in these sort of more contentious issues is we're saying you need to look at your contract, as I've talked about before. You may well need to send a force majeure notice on an open basis so that you've protected your position contractually. But by all means, if it's appropriate, have without prejudice conversations alongside that So typically you might say, here's my force majeure notice. Here, you know, I'm serving this on you in accordance with the contract to protect my position. I can't perform, and the force majeure is in play. At the same time, in parallel, you're sending a letter or you're giving a call saying, look, without prejudice, we don't want to end this contract. We don't want the, you know, us to end up in any sort of dispute over this. Can we have a sensible discussion? See if you can agree a variation to the contract. And if you can, then document it properly in accordance with the contract.
Great, thanks, Joey. And just before we kind of leave the topic of contracts generally, John, is there anything else that you're seeing that clients are kind of asking you that are in relation to the contracts either that they've entered into or potentially about to enter into? Is there anything that's coming up that you're responding to in the light of the current circumstances?
So it's whether or not, you know, the contracts that you typically negotiated pre-COVID, you know, you need to think whether or not the provisions there now give you room for performance, because before you might have been agreeing set milestones, or you may have even agreed to time being of the essence for final delivery. And now there should be a mechanism before, you know, litigation, before it all goes horribly wrong. I would recommend that clients put in a process that has to be followed so that the parties can cooperate and manage through this together. Because ultimately, none of us have really been through this before. And so the best thing to do is to use that to your advantage with your customer, with your supplier, and try and work it out before we go to force majeure, before we go to frustration, before we, you know, have to get too heavy on our relationships. Just try and work it out and have a process in the contracts for that.
Yeah.
I think also just as a final point.
Oh, sorry, John.
So just as a final point, what I'm saying before COVID, you know, everybody wanted, or depending on the industry they were in, they were very keen to have short form terms and conditions and trying to cut corners in how they were contracting with clients, understandably, because they wanted nice straightforward contracts to get your signature quicker, get the job in, get the money in. But I think what's going to come out of this now is people are going to want contracts which are more developed for these types of scenarios, which, you know, 3 months ago, we wouldn't be having this discussion. And now, obviously, we are. So I think out of all of this, people will want to look at their terms and conditions once all COVID has died away and make sure that they are fit for purpose in case the next great big pandemic or disaster happens, rather than trying to rely on one side of A4 tiny terms and conditions, perhaps.
Yeah. So we've had a couple of specific questions in. So the first one I'm going to pass over probably to Joey and Tanya. I'll just read this through. That thinking about how secure our current contracts with large blue chips are, what is the likelihood of clients instigating termination procedures on any range of clauses with a view to reducing their costs, and this being tied up in stasis whilst professional services, legal advice and the courts themselves are understaffed? Tanya, is there anything there about the likelihood of clients instigating termination procedures under any kind of range of clauses? What are the things that they might be looking for?
So I think under English law, a contract and a party's obligation to provide services is in principle absolute. So unless you're prevented by force majeure or frustration, or you've got some contractual outs, you have to provide the services and you'll be in breach if you don't. So I think, again, you've got to get into the level of detail of looking at the contracts. I don't think there's no one answer that I can give that will cover everything, but it's going to come down to the termination triggers in the contract. So what sort of termination triggers are there? Invariably, we'd have termination triggers for material breach. That's a breach that goes to the heart of the contract. So again, it's not something trivial. It's got to be something fairly significant. Sometimes also drafted as significant breaches over a period of time that together would constitute a material breach. So again, you can perhaps look at whether you can get out there. If you've negotiated your contracts well, perhaps a termination of convenience right. It might cost you a little bit of money, but you might have the flexibility to get out that way. If your supplier is looking shaky in terms of financials, you might have the ability to terminate for insolvency. And again, in larger outsourcing contracts, we invariably build in some flexibility around that so that clients can get a bit of a heads up as to the financial status of their suppliers, so that they can put in place a plan B if need be. But the devil's in the detail of the contract, so you're going to have to go to the termination triggers there. And as Joey pointed out, if you terminate a contract unlawfully, you're going to be in a world of pain. So.
Thank you. And one more question that's come in. I know none of us on here are real estate lawyers, but I wonder if anybody has seen this situation or could offer some help. So someone said, I'm interested in the implications of stopping paying rent and rates on the studios we are no longer using, as all staff are at home and we face an uncertain future. I mean, maybe bring that into kind of general contract principles of not being able to pay or not being able to perform. I wonder, Joey, is there anything that you can give some advice on there?
Yeah, well, unfortunately, as Tanya says, you're tied to your performance of your contract, which would include paying rent and obviously rates to the council. I mean, the government's bailout package includes some help in terms of business rates, for example, and obviously in terms they're looking at rent for at least for private individuals. So I think we'll have to wait and see. Otherwise, it's going to be a case of what are you contractually required to do, and can you have any discussions with whoever your landlord is around this? Actually, just a quick point on what Tanya was talking about previously from the court's perspective about cases getting tied up. I think it's absolutely true that's going to be the case. So the courts are grappling with the concept of moving everything remotely. There was various things coming out over the course of yesterday and the previous days about that. Obviously, the sort of Johnson's announcement last night has changed things again, but the courts are saying that parties should be trying to settle things, and going to court is always an absolutely last resort, but this is incredibly important now because you could end up tied up and there is going to be delay. They're also obviously trying to do remote trials, etc., but there's all sorts of problems with that around technical issues, open justice. Can you actually have a witness sworn in remotely? So there's going to be a whole heap of problems coming up. So yes, I think strategically, unfortunately, some parties may be thinking, well, I'm just going to exit this contract and let the dust settle when it settles because it's going to take forever to get it to court. Having said that, there are still emergency procedures in place. So injunctions are still available. They've always been available on a telephone basis for something suitably critical. So if you're impacted in that way and it really does have that degree of urgency, then there are still those resources available. But yeah, I think, unscrupulous parties, there are some tactics that can now be deployed based on the fact that there's so much chaos and disruption and there will be delay in the legal process.
Yeah, understood. John, just bringing you in here because I think you had something that you wanted to say in relation to the last question about rent and rates.
Yeah, I think definitely you can negotiate with your landlords here because the government announced yesterday, I think it was, that they're going to give extra protection for businesses with bans on evictions for commercial tenants. I'm just reading the headline here. Extra protection for businesses with ban on evictions for commercial tenants who miss rent payments. So if you were to miss a rent payment, you're not going to get kicked out tomorrow. But one of the things that we're seeing in the commercial property markets with our team is a few deals have just paused. And what the agents are saying simply is no one's looking at property at the moment, absolutely no one. So you've got a good negotiation point in that even if you pause your rent, or maybe the landlord can take it from your rent deposit deed, so you're keeping your cash flow in your bank account, they're not going to be able to get someone in to replace you. So with the government protection, plus using your rent deposit deed to pay the rent, you should be able to negotiate something with your landlord, I would hope.
Great, thank you. Bring in Justin, because there's a couple of questions coming in around employees and employment, and particularly in relation to furloughing employees. How much notice does an employer need to give? What's the process that needs to be followed? And how does that affect your employment contract? Can furloughed staff work elsewhere?
So good morning, everybody. I think it's something that obviously the Chancellor released last week, the announcement last Friday, and so far the only detail that's been provided, and it's on the government website, is a short overview for employers and also a separate overview for employees. Now we are expecting more information imminently, but the information to date is incredibly sparse. So it's difficult to have a view of exactly how this will work. What we know so far is that the scheme will be available to all UK employers, and it involves furloughing designated workers who would otherwise have been, what they say, and we're not sure whether it's meant in the legal sense, but probably not, laid off during the crisis. Now, with regards to notice, I suppose it's when the query about notice, I think, is more about consent and whether you have to go through some form of consultation with employees before you designate them as and look to seek their consent to being furloughed. Now, the overview published by the government says that changing the status of employees to furloughed status remains subject to existing employment law, and depending on the employment contract, may be subject to negotiation. So that suggests that unless there is a contractual right to amend an individual status, which it's quite unlikely in most scenarios that there will be, that you will have to go through some form of consultation with workers and employees. But as I said, at the moment, we don't have any real detail as to whether that's the case. That's just going by what the overview from the government has said. And then the other question I think we've had is, does furloughing affect your employment contract, and can furloughed staff work elsewhere? Well, again, there's no detail as to say whether this is going to affect the employment contract. It seems from the wording of the guidance given by the government to date that almost you're suspending an individual's employment. They're not dismissed, they haven't been made redundant, they're not allowed to undertake any work for you, so in theory, no, they can't go and work elsewhere. And during that period, they receive this sum that is a grant provided by the government. Now, there's a whole host of unanswered questions in relation to terms and conditions and contractual entitlement. So, for example, I would imagine that someone will continue to accrue holiday. But when it comes down to benefits, so for example, if someone has permanent health insurance, also pension, auto-enrollment rules, for example, where the employer and the employer making contributions in relation to pension, is that going to be taken out of the payment that is received, the grant, when it's passed to the employer, or is it going to be, are you going to have to adjust that payment to take into account pension, etc. All of these questions, I'm afraid, there just aren't any answers to, and we're hoping that we're going to have more information as soon as possible. And we're having lots of clients saying, how do we put this into process as quickly as possible? But at the moment, it's very difficult to say, because there just is I think in total around 10 lines of advice from the government as to how this will work.
Yeah, another couple of questions, probably directly at you, Justin, coming in from the audience. So one on that particular subject as well. New business has taken a big hit. As a result, can business development staff or business owners dealing with new business be classified as furloughed?
As long as they're employees, I can't see why you could not designate them as being furloughed. If business development staff are no longer needed, or it looks like there's not a requirement for them, and you would look to be making them redundant, then I don't see why there would be a reason for those individuals not to be able to be designated as furloughed. But again, the spirit of what this provision is going to be provided for, and this is very much, just reading between the lines of what the guidance, the very sparse guidance has been provided so far, is that the spirit of it is that if a business has no choice and it's looking to make redundancies and it has no choice but to make redundancies, that's when the furlough kind of scenario would kick in. Now, there's nothing to say that although that seems to be the spirit of it, and there's certainly no guidance as to whether there will have to be some form of eligibility in relation to when the grant is applied for. So, i.e., how will HMRC decide if the worker would or employee would otherwise have been laid off, and does an employer have to have commenced or progressed through a redundancy process? There's no information about that yet, and there's no information to say that it can't be used as part of an overall strategy, as opposed to a last-ditch effort to avoid making people redundant. Although it seems to be that it is the latter. But at the moment, there's nothing to say that people can't use it as an overall strategy. I think that's where you have to look at it from that perspective.
Yeah, and just to clarify, one further questions come in on that. I think from the announcements that have been made by the government, I think furloughing was probably made first of all in the context of kind of hospitality staff. But can you clarify just that it could potentially apply to people who can work from home, or is it just for people who effectively can't get to the office?
Yeah, I mean, I can see the point. There is the hospitality industry, the travel sector, travel sectors, etc., are going to be some of the first and hardest hit industries, and I think furloughing, is a reaction to that, and it's I suppose it's an easier system or scheme on the current guidelines to put into effect if there's more of a binary situation there where you have hospitality workers and there's absolutely no chance of them being able to come to work or continue with any work. But at the moment, the guidance from the government hasn't limited it to that. So yeah, I can see the idea behind it, and I can see the reason for the question. But at the moment, the government isn't saying it's limited to any specific sector, to any specific employee. It's not even saying that it can't be used as part of a strategic financial planning move moving forward. I have clients who are saying, look, we think we can survive paying the wage bill for the next kind of 3 months or so, but that's not necessarily how we want to play things. If we can take advantage of a scheme in order to protect our business as much as we possibly can, then we would like to. And can we use furloughing to do that? Now, as I said, it doesn't seem to be the spirit of furloughing, but there's certainly nothing at the moment saying that they can't.
Thank you. One more question that's come in that, again, for you, Justin, people are obviously concerned about kind of employees and how that all works is, I think there was a BIMA finance seminar yesterday on the webinar, and they just referenced to that saying, I think the saying is, if you had a clause already in an employment contract around short time working or layoffs, then you could continue to rely on that. Has that changed? And then the second part of the question is, if government is covering the 80% of wages to a maximum of £2,500 per month, is the employer required just to make up the 20% to that 2,500, or also all the full amount over 2,500, depending on what the person's salary is?
Okay, so the first question in relation to whether you can make use of layoff contractual provisions, I don't see that furloughing would necessarily affect that. In relation to redundancies, if you were to move to redundancies, I think you would have to take consideration of furloughing if you were going through a redundancy process. Because during a redundancy process, you have to look at what reasonable alternatives there are to redundancy. And furloughing may be one reasonable alternative, as it were, for the business to survive and not have to make redundancies. Layoff on a contractual basis, I think you'd have to be cautious with it, but I don't think it's something that you would necessarily have to, you would no longer be able to use. But effectively, I suppose furloughing is laying off, if that's what we're using in the legal sense of the word, is laying off individuals, but allowing them to receive money through the government. So it would seem to make sense to me to kind of go down that route, as it were. The second question in relation to how much does an employer have to top up? So the government guidance, as I said, there's been two sets of government guidance, and neither of them say exactly the same thing. But the one to employees on the Gov website says that an employer doesn't have to top up the difference. There's no obligation to do that. So if they want to top up the difference, they can. And based on the guidance we've got so far, they could do that. And also, arguably, they could come somewhere halfway between, I suppose, and choose to top up a certain amount or percentage, as long as I think they were consistent across all staff and making sure that they're not discriminating against any particular individual on how they decide that. I think that would be a reasonable option. But certainly the government guidance at the moment on their website says that an employer is not under an obligation to top up.
Fantastic, thank you. And just finally coming to you on the employment, unless people have got any more questions on employment, what sort of additional challenges are you finding that clients are having? I know we've had conversations with people looking to move people to a 4-day week or wanting people to salary sacrifice. What are the kind of issues that your clients are facing and what you're advising on?
Yes, I mean, when this first started, it was, and when there was less of a lockdown, it was more about sick pay and how they dealt with sick pay and how they approached individuals, for example, who were, and generally I think a lot of people are, too worried to come to work because they feared that they would catch coronavirus rather than actually having any symptoms, and how they would deal with sick pay in relation to a circumstance like that. Everything is evolving in a matter of days. That's not so much the concern now. Now, with Johnson's announcement last night, which was unfortunately, it's obviously a very difficult thing for him to have to do, but when you drill down into the detail, can people go into work today? And they're the kind of emails that we're getting this morning. Can my staff can't work from home? It's not realistic for them to be able to. We're not being difficult about this, but we do feel that we can operate safely within the workplace, so effectively ensuring that there is social distancing. Are they allowed to come to work? Now, the way that the Prime Minister worded it yesterday was travelling to and from work is permitted, but only where it's absolutely necessary and cannot be done from home. Now, that was slightly ambiguous when you're trying to look into it for employment purposes, because it's not clear whether the work had to be necessary or whether the travel to get there had to be necessary. And then an hour later or so, the government published a document entitled Full Guidance on Staying at Home and Away from Others. And that guidance said travelling to and from work is permitted, but only where this absolutely cannot be done from home, which put a slightly different slant on things. It suggested that work didn't need to be necessary, merely that it absolutely unless it absolutely cannot be done from home. Then there was a tweet from the government saying the only reasons you may leave home are to go to work if you're a key worker. So that was another message. And then finally, the Mayor of Manchester, actually, Andy Burnham, tweeted, "Okay, final tweet, everyone. I've now spoken to Number 10 and had it confirmed that people can leave home to work as long as they fully observe the 2-metre distancing rule." So again, seeming a little conflicted with the stay-at-home message, but I think again, it's the can people go to work today is a big question that everyone's asking. No employer wants to breach their health and safety rules, and so our advice, I think, at the moment is you have to look at how you're internally set up to work. If individuals can work safely, if they are able to get to work without contravening the guidance and the guidelines set down by the government, then according to what's been said so far, they are able to do so. So that's the kind of question we're getting on this morning, right now. I suppose the only other queries that we are having this at the moment is IR35, which is another huge topic. So I won't go into it too great deal, but a lot of individuals are, a lot of companies are concerned that where they've made status determinations in relation to their contractors or contractors that they're passing through to customers, what happens about those now? And I know that a lot of contractors are very concerned about that, because whilst IR35 has been postponed, there is still a document out there that states that someone, if it was deemed that in that way, is inside IR35 and should be paying tax. So that's another thing that we're having to tackle.
Great. One final question before I give you a pause for breath and take another question related to contracts. But Justin, one final question that's come in says they've taken on 3 staff this month, 2 active, 1 starting on the 30th of March. So beyond the 28th of February on the books date, is there anything that they can do in relation to those people?
I think so. 2 are active and 1 starting on the 30th of March. So beyond the, well, what can you do in relation to them? Well, I think the first question is, can they continue to work? I'm assuming that the question, why the question is being posed, is that they are that they can't, and therefore they can't come into work and you can't continue with them. I think it's the usual processes, really. It's looking to see whether they can work from home. It's looking to see whether they can carry out the work, if they can work it within the workplace, whether they can work from home. And if they can't do that, if you are looking to make redundancies and go down that route, then whether you would look to furlough them. The other point here is, and it's something that I think would need a little more advice on, but essentially, if someone doesn't have 2 years service and there are no issues of discrimination, etc., then arguably they wouldn't have any redundancy rights or unfair dismissal rights in any event, and therefore it is essentially a more straightforward step if you were looking to dismiss. But again, without knowing the exact details, I think it'd be sensible to take further advice on that as to whether you wanted to take that step.
Yeah, great. A question we've had in relation to signing contracts. So wanting to make sure that you're continuing to do work, looking to agree something in for a future event, potentially so running an event itself that's then dependent on this pandemic being over. What advice, John, and I'll come to you first. What advice could you give for people who are looking to enter into that kind of contracts? What sort of clauses would they really need to focus on in those agreements?
So certainly you can contract for, after COVID has gone away, because of course one day it will go away. But really we need to put in place provisions that allow a party to be able to exit without being penalized, because you may enter a contract now thinking, okay, we can keep going for the next 2 months or whatever. But if you need to be able to exit, unless you've got that right for termination for convenience, and hopefully without a penalty for exercising it, you're not going to be able to get out and you're bound. You may also want to have a mechanism, depending on the negotiation and the type of project, you might want to have a provision that says that the parties both need to agree before the next milestone is moved on to, and unless both parties agree, then the contract ends. So you can be creative, I think. The one thing you have to remember, of course, is that an agreement to agree isn't going to be legally binding. So you want to get that balance right of committing whether you're customer or supplier side, committing the other party to the deal, but protecting yourself in case you want to be able to exit. I think termination for convenience is going to be something which is much more sought after in a lot of agreements. And I think, as I said in one of the earlier answers, having a mechanism to make the parties come together and talk and try and resolve any problems they're having before someone can just yell out material breach or termination, for example, having a process that can be followed, because this is all uncharted waters for everyone. I think, everyone should be thinking creatively about how we help each other to get through this.
Sure. Tanya, Joey, anything to add in relation to that?
Yeah, so I think we touched on the force majeure clauses at the beginning of this session, and I think they're key. So make sure that you include them in all your contracts and be very clear about what constitutes a force majeure event, how long it has to be occurring before you have rights to either suspend or terminate, who bears any costs. You're going to have to go through the steps to work out what you need to include, but make sure they're very, very detailed. You might want to also consider whether you include specific rights to vary the contract if certain events occur. So you might want to be able to vary a timetable or volumes or even the prices, actually, if these sorts of COVID restrictions are implemented again or continue. John pointed out the rights to terminate, and I think also potentially rights to suspend if there are border closures or other government restrictions put in place. And I think if you've got a really key supplier that you're looking to negotiate with, I'd be looking to get a heads up about any financial issues. So think about whether you can include some financial distress events provisions so that if the supplier is getting into tricky waters financially, you get a heads up. They have to notify you contractually. And also look at business continuity planning, yours as a company, and also your suppliers, and make sure, again, contractually, you're putting on them an obligation to keep you informed as to what their BC plans are, when they have to implement those, when they have to test them, etc., so that you've got some protection there as well.
Thank you. So I know we're coming up to time. We've got a few minutes left, so if people do want to add an additional questions in, I just wanted to say a couple of things about signing documents before we go. I was going to touch on some of the government loans and government grants, but actually we're finding that news is coming out about that almost by the hour. So we don't yet know a whole lot more other than what's been put on the websites. I can share some links with you, Holly, after this that can be made available. There's a lot of information starting to come out there, but we're yet to see the full detail. It's more around what is the plan in terms of some of the schemes that the government are looking to put in place. Just practically, though, we're having quite a number of questions in around how people sign documents now that they're working remotely. For the most part, for contracts that just require one signature, so what lawyers call kind of contracts underhand, you're completely fine. There's a set process for signing remotely that lawyers have got down pat for many years. Whether that's by signing electronically, so using something like DocuSign, or having the documents emailed to you that you then print off, sign with a pen, scan, and then email back, that will all be fine. The difficulty comes when there's a deed that requires two signatures. And part of the problem is that there's a real mix of case law. So there's no real clear view of whether a witness has to be physically present. Certainly the side that I'd favour is that whilst the witness has to witness the signature, he doesn't have to sign his own version of that signature, so could a countersign and say I've witnessed in the presence of the signatory, but has to be there to watch the signature being placed onto the document. Now, you would have thought with the video calls like this, or being able to just do a WhatsApp call or a FaceTime call, we could get around that by having a call between two people, one of whom watches the other sign a document or press a button. But we're not quite there yet. There's a working group that is currently looking at this, and we're hoping that as part of the information that comes out on the coronavirus bill that might be included. But frankly, I think it's probably way down their list of things to consider. But hopefully we get some movement on that soon, because you can't on the one hand tell people not to be more than 3 people or more than 2 people in groups together and then still insist on witnesses who have to be independent somehow turning up and countersigning documents. I think in practice, for the most part, unless it's something like a power of attorney that specifically has to be a deed or something in relation to a transfer of land, probably the first question is, if you're presented with a deed, is does this have to be a deed? The vast majority of deeds that are signed as deeds are because there's no consideration clause. But we can add in there a nominal consideration, and that just means that you can sign with one signature rather than 2. So there are some practical things you can do, but ultimately we're not yet in that place of certainty whereby having a video call and watching somebody sign a document is certain to be a validly witnessed and executed document. Now, I think it would take probably a judge having a bad day and taking a real interpretive view of what the law is to say that that wouldn't be valid, but we're not yet at that point. On that, I wanted to hand back to Holly. Thank you very much for attending, everyone. Thanks to Joey, to John, to Justin, to Tanya, and to BIMA for putting this on. I think what we're going to do afterwards is make a whole lot of information available to people. We have a COVID-19 hub full of information, and we can provide links to that so people can find out more on topics that we've covered here and topics that we haven't covered here. But if anybody has any specific questions that we weren't able to answer today, then we'll also provide our email addresses after this. Please do get in touch. Please ask the questions, because hopefully one of us or more in the wider teams will be able to help.
Thanks, Andy. Thanks, everyone. That's extremely helpful. I can see one last question came in from David Lockie, but we'll make sure that gets answered on, if you want to do it now, or make sure we get it answered on Slack.
I'll take that anyway, because we haven't seen anything in relation to company directors so far. I can probably have a think about that and get back. So yeah, it's a good question. So
yeah, as Andy said, and yesterday reflected this as well, everything's changing so quickly. So we will continue, as different government advice, different grants come out, etc., we will try and run these as often as possible, in order to help you get the best advice. We'll be following this up with an email that will provide any of the links that Andy just mentioned. This whole session will also be available on our YouTube channel. Please sign up to Slack, where there's a specific COVID-19 channel, but there's also a marketplace where you can start to share resource, where maybe you've got people who have downtime, and also just, offer your services. What else? Go to BIMA events or BIMA Eventbrite to see what else we have coming up. But that's it from us. Thanks to everyone, and have a good rest of the day. Thank you.
Thanks, everyone.
Thanks.
Thank you.
Thanks.